I'm Jack McMorrow. I am the co-chair of the Beverly Hills Bar Association Family Law section. Welcome to Seeking the Truth, applying the Dependency Hearsay Exemption to Family Law DVPA matters. The Family Law section is sponsored by White, Zuckerman, Warzowski, Luna, and Hunt, Lawyers Mutual Insurance Company, SoberLink, and Our Family Wizard. White, Zuckerman, Warzowski, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Learn more at wzwlh.com. SoberLink provides objective, real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To help ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interests. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, this discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of areas of practice, including family law. Learn more at lawyersmutual.com. Our Family Wizard is a co-parenting platform designed to help families communicate more effectively, reduce conflict, and create reliable court-admissible record. Features like tone meter, AI, shared calendars, expense tracking, and in-app audio and video calling help support compliance and better outcomes for families navigating custody matters. With that said, I am delighted to introduce our speakers for today, Judges Geanene Yriarte and Hank Goldberg. Judge Yriarte, I asked about this. I'm so sorry.
Oh, no, it's okay.
Why don't you say it?
Yriarte.
Judge Yriarte serves as a judge of the Superior Court of Los Angeles County in California. She was appointed to the bench by Governor Arnold Schwarzenegger in 2009 and has been reelected. Her current term extends until January 8, 2029. Judge Yriarte earned her bachelor's degree from California State Polytechnic University, Pomona, and her JD from Loyola Law School. Before her judicial appointment, she worked as a deputy district attorney for Los Angeles County. Judge Goldberg has earned a statewide reputation for his expertise in family law and general litigation matters. Appointed to the Los Angeles Superior Court as a judge in 2003, he spent 6 years in criminal court and 10 years in family law court. He managed all types of family law disputes and also has extensive experience handling high-profile and celebrity cases as an assisting supervising judge of family law. For 4 years, Judge Goldberg ran the Family Law Settlement Court, where he settled thousands of family law matters and related civil cases. His exceptional settlement rate earned him an excellent reputation for resolving matters and offering creative solutions for complex financial and child custody matters. He served 2 terms as the assistant supervising judge of the Family Law Division. And now, let's get started with a wonderful presentation. Thank you so much. Take it away.
Thank you.
Good afternoon. Thank you to the Beverly Hills Bar Association for your continued dedication to continuing education to the bar and to the bench. Today, we're talking about a hearsay exception that was developed in dependency court that allows admission of hearsay statements of children to prove abuse and neglect. That's in dependency. but this exception is now applicable in the DVPA in sexual abuse cases. You need to pay special attention to this case law and fully understand the history of how this exception was developed and came about, so you'll be prepared when you encounter this one in court.
For many years, dependency has had their own statutory and case law exceptions to the hearsay rule. And we in family law thought that we were witnessing all of it from a safe distance. But apparently that is not the case. The gates have been opened, so to speak, and it remains to be seen how much hearsay is going to come through. This is a new area of law for us. Our goal is that by the end of this presentation, you will feel a level of expertise and comfort with it. You will know more than about 95% of family law attorneys. And if you're still a little confused, don't worry. That just means you understand it.
Okay, so the case is in re marriage of MP versus MC. And in this case, wife and husband were getting a divorce after 6 months of marriage. In July of 22, she filed for the dissolution, and then 9 months later, she sought a domestic violence restraining order alleging that husband had sexually abused her 13-year-old daughter. That was from a separate relationship. Please note that wife and husband did have a 4-year-old child together. So contained within this litigation were the custody and visitation issues as to that 4-year-old child. Now, the 13-year-old daughter of the wife alleged that the husband had touched her vaginal area. And then upon further reporting, she had indicated that there was a second day where he had actually stuck his fingers into her vaginal area. During the hearing, the wife's affidavit brought in the child's statements, and the husband objected to those statements in the affidavit, saying, look, the 13-year-old child didn't testify. That's hearsay. I object. Well, the court allowed it in, and then the court issued the domestic violence restraining order. It was appealed, and the Court of Appeal said the child dependency hearsay exception applies to the DVPA proceedings based on sexual abuse of a minor.
And the court articulated three prerequisites to getting in this evidence that actually come from one of the seminal cases we're going to be discussing with you, which is the Cindy L case. In Cindy L, it says that these are requirements, presumably the proponent has to establish to get the evidence in. The first is the proponent has to show that the time, content, and circumstances of the statement must provide sufficient indicia of reliability. So I just want to highlight this. So this exception, like many statutory hearsay exceptions, contains a reliability requirement. If it's not reliable in the trial judge's view, it's not coming in. However, in MP versus MC, they said that it was reliable because the 13-year-old had made consistent statements on different dates in different settings to different people, and the Court of Appeal at least felt that that was an indicia of reliability. Second, the minor must either be available for cross-examination or there must be some evidence which corroborates the statements made by the child. Now, again, Cindy L said this was a requirement, but there was no evidence in MP versus MC regarding the child's availability one way or the other. So it seems as if we're going to talk a little bit more about that. This element number 2 may be downplayed or maybe even ignored by this new case. They said that the respondent could have subpoenaed the child or witness to the statements and apparently did not do so. And then the third requirement is the opposing party must have had adequate notice that the statements would be introduced at the hearing. However, it would appear that the declaration, the DVRO, disclosing what those statements are in and of itself is considered to be adequate notice in order to be able to introduce those statements.
So if we look at that element 3, no, actually element 2, where the respondent could have subpoenaed the child or the witness in this case. So does that now mean, Judge Goldberg, that before you start a restraining order hearing, you actually have to subpoena the other parent to the hearing, thereby subpoenaing the child, requesting that they
Yeah,
produce the
perhaps
child
the
to
other
the hearing?
parent, because it may be that the respondent in the DVRO has potentially no custody or maybe monitored visits, as is so frequently the case. Um, there's an unwritten rule, or at least there used to be an unwritten rule in family law, that you don't subpoena a child to the hearing, or ask a child to participate in a hearing without clearing it first with the court. And as a practical matter, that may be difficult to do, impossible to do, unless there's a continuance. But I would try in some manner to discuss it, at least with opposing counsel. Gosh, I know that you're relying on this relatively new for us and family law hearsay exception. Are we going to subpoena the kid? Are we going to bring the kid in? And then better yet, try to get some pre-authorization by the court.
Correct. And then once before the court, if the court allows it, you actually don't have to issue the subpoena, but just have the court order the parent to make the child available if that's what the decision is in the case. But I agree with you. I don't think we should have children waiting outside the courtroom because we have to be prepared on the hearing. I do think that it is something that we should be approaching with the court for the protection of the minor children.
Judge Yriarte, as a practical matter, are you either yourself or your colleagues seeing this, again, for us, relatively new hearsay exception being argued? Are they applying it? Are the attorneys trying to get evidence in? What's your experience with what's happening? The case is relatively new.
I haven't had any cases before me where the attorneys have argued it. However, I have been speaking with lawyers within the community, and they have told me, in fact, the judges are using the dependency exception in just everyday hearings, in dealing with abuse, just regular physical abuse, including sexual abuse, and the judge is letting it in. So it's already being applied, but I think it's going beyond what MP and MC is saying currently. So what does a practical application of this look like? And I want to share with you a case that I had. I had a case where a 13-year-old child made an allegation that her father had molested her. The mother filed the affidavit, and in the affidavit, the mother attached the child's diary, which went on and on and on. I can't tell you how many pages that this child was writing about her struggles of how much she loved her father and how she was so devastated about how he was touching her, but breaking up the family would be something that she wouldn't want to do. And she was completely tormented in her diary. The child was outside the courtroom. So when I did the hearing, I noted the age of the child, and these two were in pro per. So what I did is I noted the age of the child, that she was 13 years old. I noted who was involved in the initial report. And in this case, she had actually went to school and she reported it to a friend. The friend reported it to the teacher. Teacher then reported it to law enforcement. Social workers got involved. Mom ended up getting, obviously, it reported to her through that realm. But I noticed how many people were involved in the initial report. I noticed that the statements were being made to other people. They were consistent. There was some indicia of reliability, also noting that the statements were contained within the diary. And again, noted the additional reporting. I noted again, the child was outside the courtroom, available for testimony. And then I turned to the father in this case, and I asked him, do you want to tell me what happened in this case? And, might you have touched her, just on accident? And he said, well, yeah, on accident. I may have just touched her breast. I may have touched her vaginal area, because what we do every week is we play with teddy bears and we wrestle pretty much so every single day. So there was some type of grooming testimony that was elicited during this hearing. And based upon that, I really felt like there was enough reliable information before the court to move on and actually assert this dependency exception. The final thing that I did is I did also ask Mom, tell me about your relationship. Where are you two at? And the mother was just bawling in court and saying how much she loved the father, and she's not intending on divorcing him, and she has no idea what they're going to do from here. There's no divorce pending. And so after I went through all of those criteria, again, I said I'm invoking the dependency exception and I'm bringing the minor statement in through that exception. So the minor child did not testify in that case. But that is a more recent practical application that actually took place in my courtroom. Let's look at where did this dependency exception begin? Where did it all start? There's two dependency cases. The first one is in re Carmen O, and the second one is in re Cindy L. And again, these are dependency cases.
And so in re Carmen O is the seminal case on this, and the case that apparently coined this statement, child dependency exception, which before that had not been recognized, I don't think, anywhere, let alone California. In that particular case, Carmen's 13-year-old sister, Ruby, testified that Carmen was crying and said that she hurt her private parts. Carmen said that Daddy put his cucumber in my private part, and a few days before, Dad put his finger in my butt. I want you to notice here, this is the language that was used, the childlike language, which was important to the court in this particular case and in others. Carmen's psychologist advised the court that Carmen would be afraid to testify in front of her father. She did not speak English. She would not testify with the use of an interpreter, and she would have difficulty in general testifying. The doctor's predictions were accurate. Carmen would not respond to questions by the court. She kept her head down and was staring at her hands. And the court found at the jurisdictional hearing that Carmen was not competent to testify as a witness, likely due to fear. I want, again, to highlight another significant point here. The court found that she was not competent due to fear. The court did not find that she was not competent due to an inability to distinguish truthful from false testimony. And the Court of Appeal itself thought that that was an interesting distinction. Now, would the result have been different if the court said that she was not competent to distinguish truth from falsity? Maybe, but not entirely clear. Carmen repeated her accusations of sexual abuse to the children's hospital social worker, saying that her father had put his penis in her private parts many times. I believe she used cucumber there again also. And this is another important feature I want you to take note of. The medical examination indicated consistency with possible hymen injury. So there was physical corroboration, another point that was mentioned by the Carmen O court. And they found that the evidence was admissible. They listed a number of factors that they felt were important in determining that the statements were reliable. Again, reliability, one of the elements of this exception. I'm not going to read all of them to you, starting with the first one. These were spontaneous statements which did not result from suggestive or leading questioning. Very important. And what I'd suggest you do, take the slide out when this issue comes up and use as a checklist to compare it against your case. If you're trying to get the evidence in, how many of these factors are present in your case in order for you to argue it should be admitted? Conversely, you're trying to keep it out. How do you distinguish this case and others from your particular case? So starting with the spontaneous statements, what we have seen, I've seen over and over again, family law cases, you know, often follow certain patterns, is we are submitted a tape recording from a parent in which they were questioning the child, sometimes in a leading and suggestive manner, and saying something like, "Oh, Billy, did mommy give you a bad touch?" And the kid says, "Oh, I don't want to talk about it, Dad." And you know, the dad's, "Well, it's okay. You can talk about it. Remember, we talked about good touches and bad touches." And finally, the kid, you know, makes some statement. That's very, very different from the Carmen O case, from the Cindy L case, from even MP versus MC. So I want you to be sensitive to that. Skipping over to the last two items on the slide. No motive for Carmen to lie or exaggerate in her statements. And also, she loved her father, played with him, and apparently did not become disaffected from him because of these sexual acts with her. Now, obviously, it's understandable that a child that was abused might become disaffected, right? It's understandable. But frequently what we are faced with in our cases is a situation in which the child has become estranged from the accused parent, and where sometimes there's evidence that the child themselves may have an agenda in the case. And so that may be a point of distinction between the typical family law case that we're likely to see, that you're likely to handle, and what happened in some of these other three published cases that we're going to be discussing with you.
The next case is in re Cindy L. Again, this is the other dependency case. And in this case, the child was 3 years old. During a nap time, she was at her daycare, and the teacher's aide noticed that Cindy was lying on her back with her legs spread open, touching her vaginal area with both hands. And when asked, "Hey, Cindy, like, what are you doing? You shouldn't be doing that. Don't do that." The little child said, "Well, my father always touches me right there." The Court of Appeal in this case said really focused on the specific due process protections that Judge Goldberg has already gone through with you, and said we really need to develop and make sure that those due process protections are there. The other thing that they looked at in this case was they found that the child in this case was not competent to testify. Similar to the other case that Judge Goldberg spoke about, but in this case, what happened was when the child was testifying, the child shut down during the testimony and was really non-responsive to a lot of the questions. And then when asked who touched you in your private part, the child said that the clown did. So the court found that the child was actually incompetent to testify, that the child didn't understand the difference between a truth and a lie. And if you're found incompetent right now, today at the hearing, then you are not competent when you made the statements. But the court said, that's okay. It doesn't matter that the child is not competent to testify. It should not be an absolute bar to the admission of the child's statements. It's simply one circumstance which is to be considered in determining whether the child's statement is reliable or not. So let's take a really close look at in re marriage of MP and MC. In this case, there are a lot of factors that the Court of Appeal considered. And the way I look at this is I'm like, the Court of Appeal was going in many different directions in this. And so that's why you're going to see when I come down and tell you there's so many different directions. But I think you really need to look at these statements closely and understand what is the Court of Appeal saying. So first of all, the Court of Appeal looked at Evidence Code Section 1360, which is a code that's applicable in criminal cases that say if there's an allegation of sexual abuse and the child is unavailable and there's corroborating evidence, that statement can come in with the hearing beforehand. But they're saying this code section here, because the statements are admitted in criminal court, it's further support that this dependency exception should in fact be extended to the DVPA. And please note that in 1360, it applies to child abuse or neglect. The appellate court stated that they can create hearsay exceptions for classes of evidence where there is a substantial need for the evidence. In other words, the only way to get the evidence is if we use this exception. And Judge Goldberg, in regard to trial courts, what do you think about that?
It's not 100% clear that the case law that we're citing does use the term appellate court and also uses the term decisional law. They're relying on evidence code sections 1200 and 160, which in combination say that the exceptions to the hearsay rule are not limited to those that are contained in the evidence code, but that to the extent that the law recognizes other exceptions, There may be other exceptions, but that's referring to decisional law. So I think the better argument, in my opinion, is that courts of appeal can make these exceptions, that a trial court cannot render its own exception to the hearsay rule.
The Court of Appeal mentioned California Rules of Court 5.250, and that says that a trial court must note that it is in the child's best interest to testify in custody and visitation matters. And what I note here is, are we dealing with the custody and visitation matter? Because we separate out custody and visitation in the DVPA proceedings. We're specifically dealing with, did abuse occur? But the Court of Appeal thought it was important to mention that code section. They stated that the notice requirement the statement will be used is the actual filing of the DVRO that contains the child's statement. And they said the respondent didn't subpoena the child, therefore it's on you. So again, you've been noticed by the filing and you didn't subpoena the child. They noted that oftentimes in the DVPA proceedings, you have self-represented litigants, and they stated that the child will have to face cross-examination from their abuser, and the purpose of the restraining order hearing is to prevent further acts of abuse. And the DVA protective purpose is broad. We must similarly broadly construe the DVPA to accomplish the statute's purpose. So what they're saying here is that the actual DVPA hearing itself, if you subject the child to cross-examination, that is abuse with which the statute intended the child to be protected from. They stated that the legislator envisioned the admission of the out-of-court statements from a minor for the truth at a restraining order hearing when it enacted the DVPA. The legislator empowered the trial court to issue a restraining order solely on the affidavit of the minor child or the person requesting the restraining order. And because the DVPA defines abuse and DV to include acts against the child, the legislator contemplated that the parent or the non-abusive parent or guardian, let me just say non-abusive parent, would be the one filing the request. So it's essentially what they're saying is that the legislator envisioned hearsay statements from minors being admitted via the affidavit without examination. And the legislator contemplated, hey, the parent's going to file on behalf of the child, therefore that hearsay statement should come in.
This language I thought was somewhat confusing from the case and subject to perhaps being misinterpreted as saying that the parent can directly file a DVRO on behalf of the child. I don't believe that's what it's saying. What actually happened in MP versus MC was the mom is seeking her own protective order. She was the petitioner in that protective order, and then the children were included as protected parties. So we'll discuss that a little bit more and why that is in a little bit.
They said that the DVPA proceedings are not subject to heightened pleading or proof requirements. The requirements of a DVPA is lower than a civil harassment restraining order hearing because it's by a preponderance of the evidence rather than clear and convincing evidence. And these factors show that the legislature was less concerned about strict procedural or evidentiary constraints and instead was focusing on giving the trial courts liberal discretion in deciding whether or not to grant the DVRO. And I think we already know this from case law that keeps coming down, that the Court of Appeal keeps saying, we give the trial court broad discretion. They have very broad discretion. And this suggests to me that there's even a broader application in regard to the DVPA with less evidentiary restraints. And then finally, the Court of Appeal stated, we're not creating a new hearsay exception. Instead, we are applying an existing exception to a comparable courtroom setting in which there is a substantial need for this class of evidence, as long as the evidence is otherwise reliable. And those words are going to be very important in your analysis in the future.
So, as I said in the introduction, as Judge Yriarte also mentioned, the question that we all have is exactly how far is this going to go? How far is it going to expand in our family law courts? And for instance, is it going to get into the area of physical abuse and neglect? So we all learned in law school, and our professors drilled into us that case law can only be cited or has to be confined to the facts of the case contained in that case. And what were the facts in these three cases? We were dealing with allegations of abuse, more particularly allegations of sexual abuse, not physical abuse. Okay. And then in MP versus MC, we said that it could apply in a restraining order case. So the question is, can it apply when some or none of those facts are present? And I think you're going to start confronting that argument. So we have a little hypothetical that we're going to play out, and we're actually going to make some arguments. I'm going to argue that the evidence is admissible. Judge Yriarte is going to say it isn't. We don't necessarily agree or disagree with either argument. We're trying to illustrate these are arguments that you can make that are lawyer-like, that are plausible, or that you're going to need to refute, and that you're probably going to see in the coming months. So in this hypothetical, a kid falls into a pool. I like to base my hypotheticals on realistic, to the extent that I can, scenarios. It seemed like in every fifth case I had, there was an allegation about a kid falling into a pool. So it's something we see a lot. So father files an ex parte for sole physical custody of the child. His declaration says that the 5-year-old child told him that he fell into a pool in mother's house and almost drowned. So we have some childlike language there. And he was alone in the pool area when he fell in. Now, this is the only little bit unrealistic part of my hypo, is that the trial court then invites the attorneys in to argue on the applicability of the child dependency hearsay exception. And now we're going to hear the argument that it is not admissible.
Okay. So I'm going to argue first that a trial court cannot create a new hearsay exception. MP and MC creates an exception applicable only in DVRO cases. And in creating this exception, they said that it only applies to sexual abuse cases, right? And here we're talking about custody and visitation. We're not talking about protective orders. And they really relied on the public policy of protecting children. And so, no, it doesn't apply in this type of hearing. And the dependency exception, again, focusing on it only involves sexual abuse allegations. So extending it over into physical abuse is no, we cannot do that. In Elkins versus Superior Court, the court held that trial courts may not establish legal rules conflicting with statutory or case law, and they specifically addressed hearsay. And the basis for the Cindy L. dependency exception is Evidence Code 1200 and 160 that says that hearsay exceptions may be recognized under decisional law. And under California Rules of Court 8.115, only published decisions have precedential value. Therefore, Your Honor, this should not come in this request for order where the child may have drowned.
And Your Honor, we argue that the court should receive this evidence. First, it is true that Cindy L. did use the term appellate courts, but they also then repeatedly said over and over that courts could create new hearsay exceptions. They did not absolutely restrict it to appellate courts. So we contend that this court, if the court thinks it is a new exception, has the ability to create it. But second, we are not asking the court to create a new exception. We are simply asking this court to define the scope and applicability of the child dependency exception. Cindy L. itself specifically said that the scope of the exception would have to be determined by the courts. They specifically left that open. We're asking Your Honor to do this. Trial courts have, quote, broad discretion to determine whether a party has established the foundational requirements for a hearsay exception, end quote. That's People versus Chisholm. So the court has a lot of discretion to determine the applicability of a given hearsay exception. It is true that a DVRO can be used to protect a child, yes. However, the health, safety, and welfare of a child, quote, shall be the court's primary concern, end quote, under Family Code Section 3020A in making custody orders. So the child's health, safety, and welfare is every bit as relevant here, perhaps more relevant than it would be in a DVRO matter. I'd like to quote a little bit from the opinion from MP versus MC. It says, quote, moreover, dependency cases and DVPA restraining order hearings involve a minor, share a similar goal of protecting the minor. On page 1111, it said, quote, but the Supreme Court in Cindy L. did not rely on any particular procedural safeguard or statutory framework that was unique to dependency proceedings in recognizing the hearsay exception. Instead, the Supreme Court focused on creating hearsay exceptions for classes of evidence for which there is a substantial need and which possess intrinsic reliability, end quote. It would simply be illogical, completely illogical, to conclude that this type of statement would come in a DVPA hearing, but not in an RFO hearing. That's not a logical distinction. We ask that the court receive it.
And one thing, Judge Goldberg, remember that in MP versus MC, they did talk about California Rules of Court 5.250, where again, they specifically noted that the trial court must note that it's in the best interest in custody and visitation matters, that they have to note it's in the best interest of the child to actually testify. And so they're saying that that code applies in evaluating this.
Yeah, even though strictly speaking, it really applies to kids expressing an opinion about custody matters, but they seem to be suggesting that by analogy, we'd have to consider it outside of that limited context.
Right. So that's what we're talking about. You really need to look at this closely and look at what gatekeeping needs to take place. So let's take a look. Let's kind of take that bird's eye view and look at the three cases that we've been talking about. Number one, we have In re Carmen O. Again, 4-year-old child, sexual abuse allegation, physical corroborating evidence, child incompetent to testify. In re Cindy L. 3-year-old child, sexual abuse allegation, physical corroborating evidence, and the child is incompetent to testify. And then when we come to MP versus MC, we have a 13-year-old child. Child is available to testify. Sexual abuse allegation only, no physical corroborating evidence. And I think if we really take a close look at these cases, I think there's been a big jump from In re Carmen O and Cindy L to MP versus MC, a huge jump.
Yeah, it seems because the features of those cases that were so important to the courts were the corroborating evidence and the unavailability of the child, and there was no corroborating evidence in MP versus MC, and there was no showing of unavailability of the child. So it's a significant leap forward.
So I guess my question is, is MP and MC go too far? That's my question. Because I think what we have now is that we have a door wide open. And I've already told you that courts are already applying this outside of the DVPA. And I think what's going to end up happening, and this is why you have to understand the case law and where this came from, is that cases are going to start going up on appeal. And I think it needs to go to the United States Supreme Court for an actual decision in this matter, or we're going to have a statutory legislative law written in this area that put those guardrail up and make sure that it is safe and that due process is being upheld. Some food for thought. Okay, I want to tell you guys a little bit about a case that I had. I had a 13-year-old bring a domestic violence protective order request, and the dad was represented in court, and the girl alleged that dad had put his hand on her leg and touched her inappropriately, and he was showing her pornographic movies. She was online during the proceeding, and we started the proceeding, and I just felt like something wasn't right in the proceeding. And I said, you know what, do me a favor right now. I want you to take that computer screen, I want you to turn it around, and I want you to scan the room for me. So she scans the room for me, and sitting right there was her mother and then the mother's boyfriend, and there were stacks of paper. And I said, I can't evaluate the credibility in this case. I need you to actually come in. So the child came in, and this was before MP versus MC. So the child came in, and I examined her there, and counsel had questions as well. But one of the questions that I asked her during the examination was, I want you to tell me what this pornographic movie looked like from beginning to end. And because in the pleading, she had reported this to individuals at school, it had been reported to social worker, it had been reported to police, and everything was consistent. And she had also made a prior report that he had touched her when she was like 3 by putting his fingers in her vagina. And so I said, tell me about this movie from beginning to end. I want to know everything about it. So she says, well, okay, these guys come in and they have guns, and there are these girls on poles and they're naked and there's dancing. And then the guys pull the guns out and there's drugs everywhere. And then they start shooting everyone and people are dying. And then the movie goes on like this. And then I looked at the other side and I'm like, do you know what movie this is? And it was apparently Goodfellas, from what I can recall. I've never seen the movie, but apparently it was Goodfellas. It certainly was not. The bottom line is what I'm trying to get the point to you is that it was not a pornographic movie. But I want you to imagine in the era of MP and MC that had the dependency exception been used and this 13-year-old child was not subject to cross-examination, based upon the pleadings, because there was a TRO issued, based upon the pleadings alone, that would have been sufficient to restrain the father. Please note that also in this proceeding, there was some type of custody and visitation, some bad custody and visitation that was going on between the parties. And I believe it was in another county where DCFS had been called historically, police had been called. There was all kinds of conflict between the parties. Huge injustice could have been done in that case had that child not been subjected to cross-examination. And so when I talk about gatekeeping the truth, we have to be really careful in the use of this exception to make sure that we really are getting to truth. Judge Goldberg, what do you think about reliability?
They're placing a great emphasis on it, and it's obviously a fact-driven issue that needs to be resolved and argued. And again, I'd use that checklist that came from In re Carmen O. And then anything else, the checklist isn't exclusive. Anything else that you logically think either supports or detracts from the reliability of the out-of-court statement. I think a lot of courts are going to be focusing on this issue, and it in essence will become the beginning, middle, and end of the analysis. If the judge thinks it's reliable, likely to come in. Judge thinks it's unreliable, the judge is going to keep it out.
But let's really think about MP and MC, because the child, and think about our everyday family law cases, the child made the statement to, I can't remember an MP versus MC, but the child made the statement to one person, then made it to a social worker, made it to the police, made it to the parent. And they said, you know what, that's reliability. And how often do we have that? Because in my case, I had that. I had multiple statements to multiple people. And how often do we have that in our family law cases? And I guess my question is that really the establishment of reliability?
I mean, and they say it is. And so you can obviously cite it. It's published law, but the evidence code defines a prior consistent statement, recall, as being a statement that's consistent with the in-court testimony and that was made before an inconsistent statement or before a motive to fabricate. And I do think that that is very reliable. I have considered that to be extremely important evidence in a variety of contexts, including DVPA matters, where the person, before there was any motive to fabricate, was saying the same thing. But that is not the type of consistent statement they were talking about in MP versus MC.
Mhm. Right. So what does it look like if you're making a record? And I'm just going to play the hat of, if I'm on the respondent side and I'm faced with this, what's your record going to look like? I suggest that you file written points and authorities. I think it's going to be so important to protect yourself on appeal. And so a written points and authority addressing all of the areas. Remember when I said when we took a close look at MP versus MC and the court was kind of all over the place and saying it's coming in because of this, this, and this, I would really analyze all of those areas. But the first part is obviously, I'll say due process, due process, due process, because it's so important in these cases, the gatekeeping of evidence and understanding the due process rights that parties have in hearings and making sure that is fully upheld. They had said initially, right, we're just applying it to a similar court, but are we really applying it to a similar court? Because the consequences are very different in dependency court. Further, we have different rules, completely different rules in dependency versus family. They're totally different. I can remove a child on day one under emergency jurisdiction where it takes them months to remove the child and they have to go through all kinds of hoops to remove a child.
And it can be done with no notice.
Correct.
No notice.
Completely different. But they said that they're similar. DVPAs are subject to lifetime renewals. Had I issued that restraining order against that gentleman for the pornographic movie, he's subject to lifetime renewal. He's also subject to potential gun loss for the rest of his life if it's renewed. CHROs do in fact have a higher standard, but they're full of admissible hearsay. You can do that entire hearing based upon hearsay. So are we really comparing an apple to an apple? That's my question.
The court, by analogy, discussed 1360, as Judge Yriarte mentioned before, which again is applicable only in criminal cases, but they were using it by analogy. But take a look at the section anyway. If you're having trouble sleeping tonight, read the section before you go to sleep. It is actually interesting, but you will see procedural safeguards that are built into that evidence code section that go way beyond MP versus MC. And one of them is that the section requires a separate hearing where the court determines, based on the time, content, and circumstances of the statement, that there's sufficient indicia of reliability. Again, going back to reliability. But since we know that this is arguable by analogy in our courts, I think that you should utilize it in asking for a 402 hearing in our family law courts where appropriate. And I could see either side doing this. I could see the side who wants to keep the evidence out asking for a 402 hearing where the court would determine whether or not it's going to come in and think about it. If the court ruled, no, I'm not going to listen to this evidence, and that is the only sufficient evidence there is, the 402 hearing could be followed by a motion to dismiss. On the other hand, if the proponent of the evidence gets the idea that the court perhaps is not inclined to receive the evidence, maybe the proponent would want to suggest a 402 hearing so that the court could take a second look and determine whether or not it should be admitted. Judge Yriarte, what about 402? I know courts are extremely busy. Is that something that you'd be receptive to in this context?
Oh, 100%. I would be receptive. I think everybody make a 402 motion that you should have a separate hearing where you're actually evaluating this. Because as I've indicated, you're not just talking about, oh, hi, I'm going to restrain you because the child fell in the pool or because, you were using reasonable physical restraint on your child, okay? This is sexual abuse. This will affect your client's custody and visitation for years and years and years to come. And I believe a 402, especially with all the due process issues that I'm seeing here, I think it should be held, period. I'm going to hold it in my courtroom if you ask for it.
And then further in Evidence Code Section 1360, there's a requirement that either the child testifies during the proceedings or the child is unavailable, and there's corroborating evidence, which kind of harkens back to Cindy L. and Carmen O. and some of the requirements that were expressed in those cases. So maybe by analogy, cite those to the court as well.
I would look at the strong factual analysis of In re Carmen O and Cindy L, because I think when you look at that bird's eye view and you look at those two cases, to me, In re Carmen O and In re Cindy L, they really do make sense, because those were cases where there's no available way to get the evidence in but through that exception. And when I look at the corroborating evidence and competent testimony of the child, it makes sense to me. MP and MC, it just has gone very, very far. But understanding where it came from, and I think a reviewing court understanding where it came from is going to be crucial. I would actually consider expert testimony regarding coaching, gatekeeping, and alienation. Because remember, in MP versus MC, the court said, well, there's no motive in this case, yet there was child custody and visitation that was an issue in that case. And I'm not saying that the mom in that case was lying or anything like that. I'm just saying I think the Court of Appeal needs to be informed regarding issues that we deal with every day. Don't assume that they understand it. And then the other thing that I would note is the new burden shifting, because in a DVPA, the burden is on the petitioner. The burden of proof is on the petitioner. But when we read MP versus MC, and I'm now requiring you to have somebody subpoenaed, that child subpoena and waiting in the hallway, it's kind of like there's a burden shifting here. And is that appropriate? I think the lawyer in that case was like, I don't need to subpoena anybody. It's not my burden, right? They should be able to sit there and they put on their case and see whether it has been met or not. I would have never expected in that case, and I don't think the lawyer did either, that statement was going to come in through some dependency hearsay exception. I bet that lawyer was shocked. Judge Goldberg.
Okay, so let's talk about a couple more points, whether the DVPA, the concepts that were developed in MP versus MC in DVPA hearings, whether those should bleed over into, for example, routine RFO hearings, kind of like in a hypothetical. And so a couple other points that I wanted to make. One is about the affidavits written by a parent on behalf of a child. Recall we saw some, I thought, confusing language in MP versus MC in that regard, which almost seemed to suggest that the parent could seek a restraining order on behalf of a child. Just again, to highlight the facts of that case, what happened was, the mom in that case claimed that her peace had been disturbed. She had been abused. Her peace was disturbed. Why? Because her child told her that she had been molested, and that disturbed her peace. And so she was entitled to a restraining order, and then the children were protected parties in that restraining order. However, under Family Code Section 6301B, which references Code of Civil Procedure Section 372B, if a child under 12 years old cannot seek a restraining order on their own behalf without having a guardian ad litem. So if it is the case that for some reason the child themselves is the petitioner trying to seek a restraining order and they're under 12, then they need to get guardian ad litem. Over 12, it's discretionary with the court whether or not it's going to require a guardian ad litem. But I just want to highlight that distinction there. Also, the dependency court used as hearsay, but there is a distinction that was alluded to by Judge Yriarte, and that is that in dependency court, the guy alluded to it as well, the social study reports, which are chock full of hearsay, come in. So hearsay is used to a much greater extent in dependency matters than it is in family law matters. And then finally, as I think both of us talked a little bit about, let's concentrate a little on a motive to fabricate. So in MP versus MC, they said that mom was credible and there was no motive to fabricate. But think about how that compares to our typical family law proceeding, where usually what happens is there was a lot of litigation in a high conflict custody dispute that occurred even before the allegations of sexual or physical abuse or neglect had ever been made. So in many of our cases, not all of them, but in many of our cases, there is going to be a significant showing of a motive to fabricate.
And can I also state, going back to should the DVA protection be extended to the actual hearing? Remember that the Court of Appeals said one of the protections of the DVPA is to protect that child from the actual hearing. And is that really what was intended by the legislator? Because I think that argument, if you want to say that, then anybody who files a DVPA, whether it be an adult or a child, everybody's subjected to future abuse just by the hearing itself. And I don't think that's what the DVPA was intended to protect at all. That's not the way I see it. The other thing I want to make note of with MP and MC is the fact that the court found true that the parent's peace was in fact disturbed. Just keep this in mind, because historically it's been, if you see the child being abused, that would disturb your peace, but it has to be done in your presence. But now we've taken another expansion and more broad view, which is what we're doing here with MP and MC.
Yeah, just hearing about your child being abused.
Yes.
Can cause your peace to be disturbed and therefore abuse within the meaning of the DVPA.
Yes.
Okay, so let's talk a little bit more generally then about other rules of evidence relating to the admissibility of out-of-court statements by children that are applicable in our family law courts. And so I take a three-pronged approach, or three-element test approach to the issue of admissibility of out-of-court statements. And the first question is it a statement at all? Does it qualify as a statement? The second is it hearsay? In other words, is it coming in for the truth of the matter asserted? And then and only then can we get to element number three, or question number three, which is there an exception, which is what we've been talking about so far, which is a new exception to the hearsay rule. But I want to talk a little bit more about elements 1 and 2, because so often we, and when I say we, I mean even us judges, skip over that, and we simply jump to, okay, counsel, what's the exception? But we haven't really analyzed, is it a statement? Is it hearsay? All right, so step one, is it a statement? A statement under Evidence Code Section 1200 and 225 is either oral or written verbal expression or nonverbal conduct intended as a substitute for oral or written verbal expression. So it's where someone is trying to express something out of court. That's going to constitute a statement. There's another dependency case. Again, a lot of the cases in this area are dependency cases. In Geanene, another very interesting case for us. And in that case, the child was playing with anatomically correct dolls with a mental health professional who had observed that the child's knowledge of sexual issues was inconsistent with the child's age, thereby indicating exposure to sexual incidents, which was in turn circumstantial evidence that the child had been abused. Because the child wasn't trying to express anything, that was not hearsay, was not coming in for the truth of the matter asserted. It was simply circumstantial evidence of abuse. Continuing with element number 2. All right. Circumstantial evidence of state of mind is not hearsay. So, for example, a child's statement expressing fear of her father was relevant for the non-hearsay purpose of proving her fear and whether or not contact with the dad would be in her best interest. Another dependency case, this Enrique Clara B. And I know this, you think of that, you read that, say, oh my gosh, that's so startling. But here's what the court said. The court said that, quote, there is authority for the proposition that a minor's out-of-court statement that a particular individual molested her are admissible not to prove that he actually did, but has circumstantial evidence that the child believed that he did. In other words, these statements supply circumstantial evidence that she had a certain state of mind. That is, a belief that her father had hurt her and dislike and fear of him based on that belief. Whether the statement is true or not is irrelevant to this use of the statement, end quote. So it was not hearsay at all. I know that seems kind of startling, but think about how we could apply that in many, many of our child custody cases where a child is making a statement that is circumstantial evidence of their attitude about visitation and custody. The same argument was attempted to be made, however, in MP versus MC itself, and it was accepted erroneously by the trial court. The trial court said, "Oh, all right, I'm going to let in the child's statements not for the truth of the matter asserted, but for the effect that they had on the state of mind of mom. In other words, that they disturbed her peace." But the Court of Appeal correctly, in my view, found no, it's coming in for the truth of the matter asserted, therefore it is hearsay. Why? Because the statement by the child to the mom would only be relevant if it's true. Mm-hmm. Because dad committed abuse only if the sexual abuse actually occurred. And therefore, its relevancy turns on whether or not it was true. So think about that for a second. If the statement is relevant, even if it's not true, it's not hearsay. If the statement is only relevant if it is true, it is hearsay. A very simple test to apply to these cases. So let's continue on with element number 2 of my 3-part test, which is it for the truth of the matter asserted? So let's use a little hypo to illustrate this. The child says repeatedly during custodial exchanges, "There are ghosts at dad's house." And the court asks you, "Why are you admitting this, counsel?" Your answer probably isn't going to be, "I want to prove that dad's house is haunted." Your answer is probably going to be, it's circumstantial evidence about the child's attitude about custody, and circumstantial evidence that for some reason, maybe we don't know why, this child is afraid of transitioning to dad's house. It's clearly not coming in to prove the truth of the matter asserted. Similarly, false statements are not coming in to prove the truth of the matter asserted. So, for instance, in the Zach case, it's a criminal case. The prosecution put on evidence of a false alibi. They wanted to show, to introduce evidence that the defendant in that case said that he was fishing in Carmel at the time of the murders. And they also had evidence that there was a major storm at that time with 10-foot waves, so it was highly unlikely that he was actually fishing at that time. In other words, they wanted to introduce the statement not for the truth of the matter asserted, but for the falsity of the matter asserted. Mm-hmm. You'll also have occasion to be able to use that argument in our family law cases. Then finally, another doctrine that is very relevant here is the fresh complaint doctrine, which comes out of criminal cases. And the seminal case is this Brown case by the California Supreme Court. And they found that a 12-year-old's statement that she had been molested could come in, not for the truth of the matter asserted, but under this fresh complaint doctrine. In that case, the 12-year-old complained to various individuals, and the complaints were made about 2 or 3 months after the alleged incident. the California Supreme Court noted that this doctrine emanates from the 13th century doctrine of hue and cry. It used to be in the merry old days of England that one of the elements of a rape case was you had to prove as part of the case that the victim disclosed it promptly to someone. So we no longer have that doctrine, but it's kind of morphed into, according to our Supreme Court, the fresh complaint doctrine. The statement is admissible to establish the circumstances of the victim's reporting of the crime. And here are some further things that the court said regarding the fresh complaint doctrine. They said that...
Sorry.
That's okay. The evidence of the victim's conduct following the alleged crime, including the circumstances under which he or she did or did not promptly report, are admissible. They said that only the fact that a complaint was made and not the circumstances of its making are admissible. The detailed statements themselves are not admissible. And this is not confined to sexual assault cases. So you could use it in many kinds of cases, including just our routine domestic violence cases. So to emphasize, this is going to the issue of credibility. This is going to the argument, Your Honor, the witness is credible because they made a complaint. And that's what we would expect a victim to do. Or conversely, you could also argue, but be a little bit careful with this argument and how you phrase it. Maybe the victim isn't as credible because they did not report, or they delayed reporting, or the reporting was inconsistent, etc. It is relevant on the issue of credibility.
And I think when you look at everything you've been talking about on the state of mind, even when you look at RFOs and DVPA, it's all relevant. You know, the child may not have been molested, but the fact that the child believes they've been molested, that's still relevant. Maybe not offered for the truth of the matter, but it's definitely offered for the state of mind and to show where the child's at. And the court has to consider that. So you can use it for that non-hearsay purpose.
In our most recent case on the fresh complaint doctrine, the court in People versus Flores was dealing with a situation in which a 14-year-old disclosed that she had been molested to fellow students 8 years after the incident. And they emphasized that freshness is not really an essential element of the fresh complaint doctrine. And they recommend that California courts and commentators should now refer to this doctrine as the prior disclosure doctrine. So the circumstances under which the incident was first disclosed, again, are relevant on the issue of the credibility of the witness. So there are a number of avenues that you have for getting in statements under the argument, A, it's not a statement at all, step one, or step two, it's not for the truth of the matter asserted, without even necessarily and always resorting to the child dependency exception.
And I want to say that I just appreciate the direction that we're going in regard to getting evidence in where there are really issues where we do need it. I do see why the court did what they did, and I do appreciate it. But I think that, as we've indicated in the beginning and in the name of this program, that gatekeeping to make sure that we are really eliciting the truth is so important, and emphasizing due process and proceedings for all parties, I think, is something that we really have to keep at the forefront in using this exception.
Yeah, I agree. And the dependency hearsay exception does represent an admirable commitment by the courts of appeal to the protection of children, and they should be applauded and are applauded for doing that. It must also be tempered, however, with a commitment to fairness, and most importantly, in my view, to reliability, that we're relying on evidence that contributes to the truth-finding process and allows us to determine the truth. As a judge, I think most judges do appreciate creative advocacy, and maybe even pushing the boundaries a little bit. Creative advocacy is to be encouraged and applauded. However, creative overreach can be very memorable to us judges. And it is your function as attorneys to try to figure out where exactly is that line drawn, hopefully not cross it. And so good luck to you in that effort. Thank you for attending today. And may all your hearsay be reliable.
Yes. And then we have a few questions that we can answer. We can stay a little bit longer. You're all welcome to stay or go if you need to. Can any new statutory formulation actually override Sixth Amendment right of cross-examination, and how? And I think that's the issue. I think that's the issue that we're hitting on, that these cases, a lot of them really do require cross-examination. I think that's why that bird's eye view of the Cindy case and the Carmen case, when you look at that, I understand why the court did that. But again, we're making a big jump in MP versus MC in taking away really the right for cross-examination and the reasoning for that. And so that's what I'm saying. I think we really have to be careful, because if it does come to that, you guys are going to be tasked with many, many appeals. And we're going to see what either the United States Supreme Court says, or we're going to see whether there's going to be new laws written in this area. What do you think, Judge?
The Sixth Amendment right to cross-examination doesn't apply per se in non-criminal matters. It doesn't. It doesn't apply to civil cases. However, due process still applies. Mm-hmm. Okay, so you may, I believe, even cite Sixth Amendment cases, but if you're going to do it, you do want to point out to the judge, otherwise the judge is going to get angry with you. Your Honor, I know the Sixth Amendment doesn't, strictly speaking, apply in this context, but nevertheless, the considerations in some of these cases should be taken into account by you in determining whether or not this complies with due process. That would be the argument. And particularly in those cases where you think your opposing counsel is crossing that boundary that I talked about from creative advocacy into overreach on this exception.
And that's the way I understood that question, that you're really talking about cross-examination and due process. And there was a case that we have in the packet where a child was taken into chambers. I can't remember the name of it, where the parties really didn't have the opportunity. And you already have case law in support with the fact that, no, the parties have the right to examine. They do. So I think that those cases are going to be important in looking at that. The next question is, when and how would you make a 402 hearing request? And then if you make a 402 hearing request, is it going to potentially ring the bell on inadmissible evidence? And I mean, I guess this is good for me. I think it's going to go to your discussions with counsel and what's going on in the case. If counsel is not familiar with it, I suppose, and you see they're just submitting on the affidavit, at that point, mid-hearing, you can ask for the 402 and then proceed that way. Because again, I think this brings up the issue of, are you going to subpoena the child for the initial hearing or the actual hearing itself, and the problems with that? I'm not, go ahead.
Yeah, on the 402 hearing, there is no requirement per the case law, and it's mostly criminal case law on this, that you have to file them in writing. So you can make it you can do it orally. And the reason for that is just the common sense concept that if you wanted to, you could just wait until the evidence was sought to be elicited, and in that moment object to it. So you're simply advancing an argument that you'd be able to make later on. But I nonetheless think that on something this important, and that may be pivotal, absolutely pivotal, maybe you win the case or you lose the case based on the court's ruling. That doesn't happen a lot, quite frankly, I think, in family law, except in this situation. I would probably want to write out a formal motion in limine and probably include appoints and authorities. And I think we have most of the authority that you need to put into that points and authorities and most of the arguments that you're going to want to make.
The other thing is, remember, your bench officer may just invoke it himself. I mean, look what happened during my hearing. And I said, I'm bringing the statement in through the dependency exception hearsay exception. So your judge may do it on their own. So I think the 402 is appropriate, and just ask for it. That's all you have to do, is ask for it. I think those were it. Thank you.
Thank
All
you
right.
so much.
This concludes today's presentation. Thank you so much, Judge Goldberg, and thank you so much, Judge Yriarte, for an excellent presentation. And thank you to our audience. Have a great day, everybody.
Thank you.